Now we continue focusing actually on the theoretical and practical implications of the case law developed by the Court of Justice, and notably on these implications for the three categories of legal professionals that are mostly concerned by this case law. So the judges, the lawyers, but also the legal scholars. And clearly they are concerned for different reasons and in different way, but they are all concerned by this case law. So I introduce Professor Tomasz Koncewicz, who is the moderator of our dialogue titled To Trust or Not to Trust, Virtues and Vices of the LM Test and the Challenges for Judicial Cooperation. Now, Tomasz is Professor of European and Comparative Law of the University of Gdańsk, Poland, which he represents in the trial project, and where he is also the director of the Department of European and Comparative Law at the Faculty of Law and Administration. He is also principal investigator of the project Reconnect, which is a research project funded under the Horizon 2020 program, which is dedicated to the rule of law in Europe. And the title is Reconciling Europe with its Citizens Through the Rule of Law and Democracy. And he is also an attorney specializing in strategic litigation before the European courts. So Tomasz, I leave you the floor for introducing our guest speakers, which I really thank for all the work that they did in the previous days. And I leave you the task and the honor to introduce and chair your and our dialogue.
Thank you, Nicole. Hello, everybody. Can you hear me?
Yes, perfectly.
Yes. Okay, great. And thank you very much, Aida, for this amazing introduction. Actually, I was wondering whether you had an insights on my own ideas for the panel discussion, because you covered so many points that we actually want to cover during the panel discussion. So you basically foreshadowed what we would be talking about during next 45 minutes. So thank you for that, because that makes my my job much easier. And it is my pleasure to introduce our two panelists. I will step back in a second and we'll give the floor to them. So let me start with Vania Costa Ramos. She's an attorney and a managing partner at Carlos Pinto Dabro and Associates in Lisbon. She specializes in international and European criminal law and is responsible for mutual cooperation cases. She also lectures on European criminal law at the Université Libre de Bruxelles and the University of Lisbon, and has published extensively on the topics that are of direct interest to us. And then Florentino Gregorio Ruiz Yamuza, he's a senior judge on the Court of Appeal in Spain since 2003. He's a member of the Spanish Judicial Network on International Cooperation. In 2020, which is to be noted, he joined the ranks of academics because he defended successfully his PhD on the new dimension of the preservation of fundamental rights under the European arrest warrant mechanism, which he defended at the University of Huelva in Spain. He has likewise published extensively on European criminal law topics and acted as a trainer in trainings events, including trainings organized by the Center of Judicial Cooperation. So if there are two persons which we would like to consult on our today's topics, these are those two panelists, and welcome. And let me open by asking you the following question, which in a sense would build on what Aida said. Because as practitioners, I would like to ask about how do you understand the extraordinary factual circumstances of the Zellmer case? Because it's not just another case. If you read through the decision of Justice Donnelly, she makes some startling assumptions, some startling findings about where the rule of law in Poland is and how bad it is. So I would like to pick up on this and ask you about how do you understand this Zellmer case from this more systemic perspective and its long-term effect on the future of the mutual recognition within the European Union?
Thank you very much for your kind words of introduction. Thank you very much for inviting us. Vania, please go ahead. I'm a gentleman, so ladies first, always.
I'm not sure whether this is a privilege of being a lady or whether throwing me in front of the car. So firstly, I would like to thank very much to Professor Lazzarini and to the Trial Project for inviting me to speak with you in this dialogue, and also for the excellent introduction by Professor Torres. I'm here more as a practitioner, so I'll try to give my view from the ground, with the caveat that I must say that in Portugal there are really no cases where there has been a refusal on the basis of, well, there might be one case, but it's for particular reasons. But they're generally speaking, the courts are still lagging behind the Court of Justice. They are not performing. Even in cases of EAWs to Romania, for example, or Poland, and an in-depth analysis and asking for supplementary assurances regarding the prison conditions, for example, much less the rule of law. So it's our courts are not very into the topic, but I have tried to raise the topic in some cases without success. And so I hope I can give some insights of this perspective. I also work, just to give you a little bit of background, often as a practitioner, as a defense lawyer, I'm often contacted by lawyers from other EU member states as executing member states, where they will ask me either to check the case in Portugal, where the EAW was issued, or to give an opinion about legal issues or prison conditions, or so this type of issues. So that's also an interesting position to be, and to address this question that was put to open the floor. I think maybe not without wanting to be too philosophical. So mutual trust, from my view, has always been a very nice proclamation. Let's call it like this. But for practitioners, it is clear that there are often situations in which EU member states do violate certain fundamental rights, and this is shown not only by some domestic decisions, but also by the decisions of the European Court of Human Rights in certain aspects. And if we look at prison conditions, that's an area that has a lot to be said in that regard. And if we look at the way member states operate, in my practice, I have seen already before Araniosi and after Araniosi and Calderaro, some member states such as Portugal and Spain, for example, where the philosophy of the courts is to strictly adhere to the principle of mutual trust and mutual recognition. I would even risk to say, even outside of the European Union, there is this strong presumption that we should trust other sovereign states that have constitutions and have signed up the ECHR or the ICCPR and so on. So the Chalmers case is interesting, as you said, the factual basis and the way that the judge described the situation in the referral. I think it has to be seen in the context of also the member state where the request originated from, because that member state, as others, have always had a much more skeptical perspective of what is mutual trust and how far can you test in a given case whether there is a risk of violation of fundamental rights. And so, of course, that the way it was phrased, it was probably influenced by the evidence, I'm guessing, that the defense counsel brought to the case. And I don't know the whole details of this case, but they had presented a few expert opinions by lawyers. I'm not sure if they had official ones from the bar or some more institutional opinions, but they had expert opinions basically about the situation. And of course, then they used court decisions and so on. So I don't know if we can tie this to the, to another topic that we have, which is the burden of proof, and how do you raise these issues? So
I think on burden of proof we will get there. So can we give floor to Florentino now? And you are the judge. So when you see a case like Telmer that really raises those fundamental questions about the judicial independence in another member state, let us remember. So what are your thoughts?
Yes, you started by underlining the importance of this LM case, and Ida did before in a very clear manner, very accurate manner. It's a very important case because of the circumstances surrounding the case. But I'm not that. I would like to be a little bit more diplomatic and not stressing the situation in Poland, because I'm the judge in Spain, but I'm not the judge to assess the situation in Poland to that extent. Let's say the situation was very serious, to the point that almost raised a conflict, almost raised the application of Article 7, and the situation has prompted judges all over Europe to think, as in LMP case, that systemic deficiencies amount to put under the doubt everything in Poland. This is the case was so serious, and the case motivated a turning point, under my opinion, in the case law of the court in Luxembourg. But as a judge in Spain, I'm not that kind of judge executing European arrest warrant in Spain. That is centralized in Madrid. I'm an issuer of such warrants. But I have to say that the judiciary in Spain is much less influenced by that inspiring light of the fundamental rights than in some other countries. For instance, in Great Britain, there is a long tradition of keeping a close eye on fundamental rights issues, and in Germany as well. But in Spain, we have been more in favor of mutual trust. So to the best of my recollection, there is no case applying LM doctrine in Spain, and there is no case applying Aranjuez and Calderaro doctrine in Spain. We are very much in favor of executing the warrants. I'm not saying that this is a good approach, nor a bad approach, but I have discussed this very many times with colleagues from England, and they had a law dating back from the year 2003, and in that law was put very clear that fundamental rights issues have to be addressed by judges. So they have a tradition of assessing those points. It is very important, the case where the circumstances were very serious, but as I have shared with you, the two panelists, and Thomas and Nicole, for me is much more important the aftermath of LM case and the implications the case might have than the very situation generating this judgment. But I do agree the situation was extremely serious, but I'm not going to say.
Okay. So this is very helpful. Thank you very much. So my second point would be that, because you used a very interesting term, Florentino, in your introductory intervention, chain. You used the chain for the Aranjuez line of case law, but I was wondering whether LM case adds something important to Aranjuez and goes beyond a strict observance of fundamental rights and raises those issues of more systemic nature, like the rule of law. And if you read some academics, they have criticized the court for framing the LM case as a fundamental rights case rather than a rule of law case. And in the LM case, you have those hints from the court that it understands the broader perspectives from which it should be analyzed, but stops short of actually making this decisive step and sticks to Aranjuez. So can you both locate LM case within the Aranjuez doctrine and whether it adds anything important to your understanding of the mutual trust?
Yes, Vania.
I think we should exchange. Now you go first.
Well, I wouldn't mind not to be criticized yet again for putting you first. Well, obviously, this case of LM has some similarities with Aranyosi, and probably the most important was that of having to do with systemic deficiencies. But they have both cases have a lot of differences, and it is very important what you have just said, and very difficult to throw the line dividing between rule of law, fundamental rights, and procedural rights. To me, is very difficult because in a situation where the rule of law is under question, fundamental rights are under question, and procedural rights as well. And the three of them are linked. Besides that, the court has been addressing fundamental rights issues for a long time. From the Solange cases, Meloni has been quoted as well. But the court, for the first time, broached that issue of fundamental rights in connection with the European arrest warrant in the context of systemic deficiencies and in the light of the doctrine in NS, basically. So the court has been linking the pieces of jurisprudence in a way that you cannot fully understand LM without having read Aranyosi and Calderaro. So it helps to be a little bit more precise and pay attention to the differences and similarities of those cases. To me, of course, LM is much more important than the very Aranyosi, although Aranyosi was, let's say, the first, but LM broadens the boundaries of protection of fundamental rights within the European arrest warrant in a way I haven't been able to guess earlier before. Probably I am wrong because my forecast is that those boundaries are going to get tremendously expand, and nowadays we haven't seen much hints of that to be happening. But this is yes, I'm positive that would happen in the wake of LN.
Vanya?
Maybe I think there is a line, but I think the point that Professor Konchevitz made is quite important, that the court seemed to stop. So, well, yes, there was a line where the first stage the court applied apparently a more blind mutual trust, let's say, in saying the EAW has a limited grounds of refusal, and we cannot, it's to be presumed that fundamental rights are respected, we do not control, so it's up for the issuing state and so on. Then it changed to Aranyosi, and of course under the influence, in my view, of the ECHR case law, clearly. So to, let's say, be in line with the ECHR, even if there are some differences. And then this case appears, which seems to put problems that go beyond the risk of violation of a fundamental right in a surrender case, but rather affect the whole system of the issuing state, which puts, if there is no rule of law, if courts are not independent, then all rights are theoretical in principle, because you don't have the right to effective judicial protection. So, so it's basically words, not rights. But I think maybe the court in the end kind of issued a ruling which is following the Aranyosi line. It stopped short, as you said, of going further. But I think this shows also the political, let's say the limit of the Court of Justice and the political building, which is the EU. And I'm not sure, because, we have Article 7 proceedings. So did the court stop short because it found, this is not the place of making such a statement that the consequences could be you cannot cooperate with Poland. There is no rule of law, so this member state cannot be a member state unless the problems are sorted out. So maybe you are right in the sense that if you would take things all the way through, maybe the ruling would even be broader than just a fundamental rights case. But I think the court did not do it because it also, there are certain limits and it has a certain political decision in the sense that, to measure the consequences.
Yeah. I agree completely that if you look at the courtroom, you have to take into account two aspects. You have to take into account the promise of the courtroom that is offered to litigants, and the inherent limitations of the courtroom of what the judges can do. But there's one interesting point here, because when I was preparing for this conversation, I looked at LM case and tried to find the paragraphs where the court repeats Araniosi Caldararu, word for word, and there are many paragraphs that court simply quotes from Araniosi, but there are also a few paragraphs that are self-standing, like the court simply says something that is absolutely novel. It hasn't been said before. There's no reference to any case law. And I think the most important paragraph in LM case is paragraph 48, where the court says, it must be pointed out that the requirement of judicial independence forms part of the essence of the fundamental right to a fair trial, a right which is of cardinal importance as a guarantee that all the rights which individuals derive from EU law will be protected, and this is novel, it hasn't been said before, and that the values common to the member states set out in Article 2, in particular the value of the rule of law, will be safeguarded. So the court clearly introduces the language, not simply of a principle of the rule of law, but a value of the rule of law, which is underpinned by a right to a fair trial, which is understood instrumentally. Right to a fair trial is an instrument to guarantee all other rights which are derived from the EU law. So I think this is an opening, and this is the promise for the future case law to develop. So let me ask you more concrete questions now that go back to the burden of proof that you, Vanya, mentioned. So the first question would be this. Aida has laid out very eloquently for us the two-pronged case in LM case, but I would like to ask you a more practical question. Is this two-pronged test workable in practice, on the ground? What are the problems that you as practitioners can envisage moving forward? And there are certainly lots of things to be discussed here. So please share with us your practical understanding, and where are we now in terms of practicality and workability of the two-pronged test?
So maybe now I can start, we can exchange. It's fair enough. I think there are, I don't even know where to start, because there are many difficulties, and they are not the same in each member state, because they have to do with the way that the EAW procedures are built in the laws and the practices of each member state. For example, in the case of Portugal, typically this should be a quick case where the defense, I have a client, he's been detained, I will go there today to see him, the arraignment is tomorrow, or it's 48 hours. And in that session, you may oppose verbally, you may say, yes, I want to raise, imagine it's a case of surrender to Poland, I want to raise issues related to the rule of law and others, then I will get a deadline to do my defense. Normally, this deadline is between 5 to 10 days. So how can I, especially if I'm a legal aid lawyer, that is virtually impossible, completely underpaid, gather the necessary evidence to discharge the burden of systemic deficiencies, not even of individual, just to start with. And normally, you have to put your full defense already at that stage, meaning it will, let's say, set the subject matter of the procedure. So you need to put your defense and the evidence to prove that there is a systemic issue, Of course, right now, with the previous court decisions for Poland, it makes it easier to argue that there is a systemic issue. And then we get to the point of the individual risk. And that is extremely difficult in my view. I have only experience in the cases of prison conditions that are already difficult, but in the case of judicial independence, that's even more difficult. Because, I mean, what is the test? I mean, as a lawyer, I would say if the rule of law in Poland is in crisis, there is no way to guarantee that even if this judge who issued the EAW is an independent judge, that my client will not be subject to an appeal to another judge which is not independent, or that the judge who will try his case or will be independent. So I would argue that the systemic issue also kind of proves the individual risk. But this is very difficult. We don't know how the court will develop, because you could say, no, there is only a risk, and I've discussed this with Polish lawyers. If you are, for example, a person that is in the opposition or an activist, that is, if you're just a common criminal, let's say someone who did a theft or something more less interesting, then the judges who deal with those cases, they are they are fair enough. They are independent. They do not politicize the cases. They are not also the executive is not interested in those cases. This is very difficult to contradict in practice. I mean, what evidence can you bring to your individual case other than using the systemic issue to prove that your client is at risk? Of course, if your client is one of my colleagues who have been fighting very overtly against the changes and the issues in Poland, and if they are being prosecuted, of course, then that is a different case. Then you will use their political activism or their activism to say these are the typical victims of the case. But this is already what is happening in if you look at the case law of the European Court of Human Rights in extradition cases that involve these type of issues. Also, in certain issues, you need to put your client in a specific group of persons, which is difficult and also difficult to prove. Then you need witnesses. My courts in Portugal don't tend to hear witnesses to prove that the court is not independent. They will say, what can a witness say about this? So it's extremely difficult, I think, in practice to discharge.
Okay, and Florentino, what about the judicial perspective?
Yes, it was a very nice question as well, because it's not easy to answer at all. I would like to make a small distinction between initiative and burden of proof, because the initiative of proof could be in these cases could lay on the requested person or the defense of the requested person. But the burden of proof, for me, is on the executing authority completely, not just in the court, because the court has to be satisfied that there are sufficient grounds to surrender the person, but probably on the here in Spain and in many countries is the public prosecution who triggers the case. So once the point has been raised, the initiative was on the requested person representatives. Now the burden of proof is on the executive member state that has to be fully satisfied if there is any doubt that the fundamental rights of the person are not going to be endangered by the surrender. This places the position, again, of the issue member state authorities, especially judges, in a very difficult situation. Let's imagine that if you're asking the Polish judges about information regarding the particular situation of the person, regarding the particular court that is going to try the case, it's very difficult for the issuing judge to say, well, I'm issuing this, but my colleagues are not impartial. My colleagues are not gathering the requisites of a state of law foresees for judges. Is very difficult. On the other hand, we have an additional problem, which is that the ML case in ML case, the court says that the executing authorities has to rely on the information provided by or endorsed by judges. So if you're asking the judges on the ground in Poland or in Spain, what about the situation of the judiciary in your country? And the issuing member state judges says it's okay, everything is perfect. You have to trust them. So this is a circle very difficult to break. I have two more footnotes. I disagree with Vania in the thing of the procedural times, because in Aranjuez and Colorado, the court said, well, you can postpone the surrender until the pertinent information has been gathered. So although you have strict time limits in the framework decision and in your national law, you can stop the proceedings and say, well, let's see whether in 15 days or in 20 days or whatever this very relevant, important information is provided. And the second footnote is that regarding Aranjuez and Calderaro, I had thought about this point, how difficult the situation of the issuing member state judges could amount to be if those judges who are issuing European arrest warrant, but in time are sending people to prison in the very country, well, they are obliged to face reality where you cannot receive people you're asking from another member state because your prisons are substandards, but you keep on sending people to prison. This is very difficult to bear if you're a judge or if you are the person who have the last word. So we have substandards, not fitting the request sent to a foreign country, but I'm still obliged to send people who have committed crimes here in Europe. It's very, very difficult. And in the case of LM proved that although the first step of the two prongs test was satisfied because of the general scenario, the second step wasn't satisfied because first, there weren't sufficient ground to suspect that the case the court has taken that case wasn't going to be impartial, and second, probably due to the kind of information received concerning this specific court.
Yeah. Okay. So two follow-ups to that. Can you imagine asking a question of the domestic judge, let's say in Poland or in Hungary, are you independent enough? And then expect this judge to be a source.
No, I'm not.
Yeah, to be a source of reliable, credible information. So I think the Court of Justice has been a little bit delusional because it has been coming up with a test that is absolutely unworkable. Hey, judge, in a captured state, can you tell me whether you are independent? And 99% of the judges will say, of course, I am independent. And interestingly, if you follow up the LM decision with the with what happened at the domestic level in Poland, one judge in Poland that was mentioned on the arrest warrant said, I am completely independent. And the other judge said, I feel threatened by the disciplinary proceedings, and I'm not sure I will guarantee Mr. Zelmer a fair trial. And then second point is this. With this case, can you imagine a Mr. Zelmer that began as an ordinary criminal has now become the arch enemy of the state because his case gave rise to this litigation at the European level? So even if you accept that he was a drug offender, right now he's so much more. He's the enemy of the state. So his ordinary case has been transformed into this propaganda stunt. He must be punished. So if you tell me that he will be guaranteed a fair trial, come on, we lawyers should be realistic, right? So tell me, how would you listen to a domestic judge telling you that he or she is independent if you have some grave doubts about whether she or he is so independent?
Even more complicated, Thomas. Let's think about a panel of judges, 3 or 5 of them. So out of the 5, 2 of them says we are not independent, and the other 3 says we are independent. So it is very difficult. But what ML says is you have to trust, you have to rely on the information provided by your brother judges. Mm-hmm. This is a thing that probably in a future preliminary ruling reference has to be looked a little bit more in detail concerning what kind of things are you asking and who are the ones bound to answer your questions, because you cannot mix the position of poacher and gamekeeper, as they say. They are different.
And Vanya, would you like to add something to this?
I think I'm not so sure about the wording of the case of the court does not say you have to accept what they tell you. They oblige you to ask for information, which is already a bit strange, of course, to see if the court will say whether they're independent or not, whether they feel. But I think the court does not necessarily oblige you to follow that. It obliges you as executing court to independently assess that response, that information, in the light of other evidence that you may collect ex officio or, of course, promoted by the defense mainly. And here is where you can get a lot of independent evidence. It's not always easy, especially, I'll go back to the timings, but of course the defense will gather other evidence by NGOs, by lawyers practicing in the field, eventually even by other judges or NGOs of judges. So we will try to counterbalance whatever the information and the Article 15.2 says with other evidence. So then it's for the executing court to weigh all of the information and to decide. So I don't think it's not that you have to be bound by whatever the judges say, and I think especially for the reasons that have already been mentioned, that you're asking the court to say whether you consider yourself independent or not. I think that also leads the executing court to, carefully weigh the information that is provided, not to just accept it without further. And just to be clear, I wasn't speaking about the deadlines of the European arrest warrant framework decision for a decision to be made. That can take 3 years. Our courts violate that in certain cases. It's the deadline to lodge the defense, because you need to lodge the defense. Of course, you might understand it's the court ex officio who should raise the issues, but that doesn't happen in practice here. You need to raise it, and you need to raise it properly. You cannot just say, I'm afraid that because I will be surrendered to Poland, my right to an independent tribunal will be violated. This is not enough. You need to mount a proper defense with a lot of indication of the evidence already, which you are already submitting or aim to submit. But you need to, the factual basis of whatever you want to prove in the case has to be presented. And for this, the deadlines are very short. So it might undermine your case if the defense is not good enough. Just to give you, I tried to see if Portugal had any refusals or any surrenders to Poland and to Romania as a kind of example. And I was checking in the last statistics, and I found a few cases where in all these cases, people have been surrendered. And there are no cases published whether the issues of prison conditions or of independence of a tribunal have been assessed. I could not get the dossier of the case on time, but I will do that. And I'm very happy to provide the trial project with whatever information about what I found, because I was curious to know why. Because in my experience, in many cases, it's the person has consented. There was not even a defense. And the court also didn't raise it ex officio, because everyone knows about the issues in Romanian prisons. You don't need the defense to raise it. So, but the attitude of the courts, at least in Portugal, is not to take these issues ex officio. The defense has the burden of raising them, and of raising them in an adequate and concrete manner, and also of bringing evidence of what is being argued. So it is quite difficult to meet these standards in practice, at least in member states.
Okay, thank you. Nicole, would it be okay to steal 2 minutes from the Q&A? Because we have 5 minutes left.
Of course.
Then, okay, so all those wonderful points lead me to a final question. What is the future then of the LM test? We all know that those decisions have been made by the court within the framework of the preliminary rulings. And we also know that in the past, the national courts have been at times very critical interlocutors of the Court of Justice. So my question to both of you is whether you can see if the courts, national courts, could take upon themselves in the spirit of Solange, telling the Court of Justice, as long as you provide us with this unworkable test, we are unable to accept the impunity and the infractions of the rule of law on the ground, and we will take upon ourselves to ensure that the rule of law is indeed enforced and respected. So what is the future of this dialogue between the Luxembourg sticking to the LM case and the domestic courts having those many practical problems with actually enforcing the test that the court has put down for them? So tell me, what is the outlook here for the future?
Maybe I don't have a crystal ball, but but I think this is rather influenced by practical points. It might be the case that certain very proactive courts, because as we know, Portugal has never made a preliminary ruling in a criminal matters for EAW case, but the Amsterdam court does it all the time because they are specialized. So, you know, they always have doubts. You need to know more to have doubts. That's the problem. And what I think is that it's quite likely that a court, if a very specialized court like the Amsterdam court or other courts is precisely faced with this issue, well, they will ask for information from the issuing state about whether the court finds that there is a risk for the independence, and then they'll have evidence from the others, from the defense, to try to put this at stake, and that maybe they will ask for further clarification from the court on how, and try to cast doubt on this unworkable criteria, as you say, by making a supplementary preliminary ruling. This could happen in one of these countries, I guess, Germany, the Netherlands, maybe even Italy. I don't want to be nationalistic. It's just typically there are some courts for structural reasons that tend to raise more issues before the Court of Justice, and others less.
Okay. Florentino?
Yes, I agree with Vania. I think I don't think we're going back to the Solange context, but I think it's a matter of further preliminary ruling references, further dialogue, and those flows that we see in a workable test and so are going to be clarified by further preliminary ruling references. I hope so, and is the way forward that I can see right now. Yeah.
And of course, we can all see the danger of fragmentation with some of the proactive courts, like in Netherlands or Germany, refusing the surrender, and some other courts just taking this more sitting on the fence approach. And it is interesting that actually Justice Donnell in LM case, in the end, she allowed the surrender of Arthur Zellmer. And her decision has met with criticism. But on the other hand, you have more and more judges standing up and saying, no, it's not working in practice. Amsterdam court, then Karlsruhe court, saying basically this: the systemic test, once you have this general deficiency in the rule of law, translates automatically in our unwillingness to even consider the individual test, because a priori they consider that this person will not be guaranteed a fair trial. So wonderful points. And I think the question that was posed in the title of our panel, to trust or not to trust, might be extended by asking a further question. In judges we trust, ? And unfortunately, we don't have a crystal ball. We don't know the answers right now, but that's the beauty of law. And that's the beauty of European law. It develops in chains, right? You build chain novels, you add plots, you have new actors, and let us hope that the national judges will step up to the plate. My final remark is this, to wrap up this discussion. I think more attention should be paid to Article 19 of the treaty, which mentions that the law is to be observed in the application and interpretation of the treaties. And then the right to an effective remedy is a general principle of EU law. And this is a huge potential, because if in the past the court has shown us how it is ready to use the term the law, like the EU law is an open-ended concept with many moral undertones, the rule of law. So the potential is out there, and it is up to lawyers like Vanya and up to the judges to listen and try to come up with some workable solutions that in the end will ensure that indeed the EU law is a community based on the rule of law. It's an aspiration, but it's an aspiration worth fighting for, I think. So let us go to the Q&A. We only have 12 minutes, and don't blame this on me. I did my best. 12 minutes.